This is Bloomberg Law with June Grasso from Bloomberg Radio.
I'm going to need you to walk me through what happened. Part of this process is the two of you reconnecting, growing closer as brothers.
Eric and I killed our parents together, so I'd say that makes us pretty close. Eric, I know that they would be proud of us.
Millions of people watched the Netflix series Monsters. And then Netflix released the documentary The Menendez Brothers. So about 3 decades after Eric and Lyle Menendez were sentenced to life in prison without parole for the brutal murders of their parents, their case was being talked about again and reframed, with their claims of molestation seeming more compelling today than in the 90s. So now the Menendez brothers can see a path to walking out of prison, thanks to the resentencing recommendation of L.A. District Attorney George Gascon.
And I do believe that the brothers were subjected to a tremendous amount of dysfunction in the home and molestation. We're very sure not only that the brothers have rehabilitated and that they will be safe to be reintegrated in our society, but that they have paid their dues, not only for the crimes that they committed, but because of all the other things they have done to improve the life of so many others.
Gascon is recommending that the brothers get a new sentence of 50 years to life. And because they were under 26 years old at the time of the murders, they'd be eligible for parole immediately. But the brothers have several obstacles ahead before they can walk out of prison: a judge, the parole board, and the governor of California. Joining me is L.A. trial attorney Dave Ring of Taylor Ring. The DA said his office was split on the case. The Menendez family is split on what to do. What led to his decision to call for resentencing?
There's a lot of factors that go into that. You know, George Gascon came to Los Angeles as a district attorney a few years ago on this platform of being a progressive district attorney, of trying to do away with mass incarcerations, really a big reformer of the criminal process, rehabilitation instead of punishment. That was his platform. And so this case, if you believe George Gascon, this was a case where he felt that these brothers had served, 35 years for a crime that maybe they had some plausible excuse for committing, and he made it public that he felt it was time for them to be resentenced so that they could be possibly placed on parole.
The brothers' first trial ended in a hung jury, actually 2 hung juries, because there were 2 separate juries deciding the case for each brother. What might have made the difference in the second trial where they were convicted?
No doubt about it. It was the evidence involving sexual abuse. So in the first trial, which was televised and which was huge news, not only in Los Angeles, but across the country. I mean, that was a big trial. There was a lot of evidence that was allowed that the brothers had been allegedly sexually abused by their dad, emotionally and physically abused by both parents, and that was why they committed this horrific murder of their parents. 2 hung juries. So then trial number 2, and, there was some backlash about that outcome, that maybe, somehow they were getting away with these horrible crimes. And so for whatever reason, the trial court really curtailed the evidence in the second trial. There was very little about being sexually abused, and it really focused on their motivations and all the acts they committed that showed this was a planned murder. And so in the second trial, you got 2 convictions for murder, and they were sentenced to life in prison without any possibility for parole, which brings us up to today.
Times have changed, and the DA sort of referred to this, the years chipping away at the stereotypes that existed more than 30 years ago. Mark Garagos, the lawyer for the brothers, said, if they were the Menendez sisters, they would not be in custody. We have evolved. It is time. How have changing attitudes affected this decision?
Our society has absolutely viewed children who are abused in a far, far different light than they did 30 or 40 years ago, and particularly boys who are being abused. No doubt about that. And so that played a huge role in this decision coming about now that these boys should possibly have the chance to be freed from prison and be placed on parole and come out in the community again. And of course, he had all the support of, the Netflix shows and other shows that kind of, supported their fact that they were abused and they had a plausible excuse for this and we should forgive them for 35 years in prison. And he has big celebrities like Kim Kardashian supporting them. And so I think that's a big factor in what brought this about, a huge factor. On the flip side, however, that's if you believe they were abused. You brought it up at the beginning of the interview, that there's really two factions out there, the faction that thinks they should be released and the ones that think they should stay in prison until they die. And the reason why there's a big group out there that thinks they should not be released is because if you go back and look at the evidence in these trials, it's a little bit sketchy on the sexual abuse. There's a lot of reasons to believe that this was a made-up defense at the criminal trials.
There was new evidence that played a part in this as well.
And that's also a reason why we're here today. And so what came about is really two things. There was an allegation a couple of years ago from a former boy band member. The band was Menudo. They were big in the 80s and 90s. And he came forward recently and said that he had been sexually abused by the brother's dad. The second piece of evidence was a letter that Eric Menendez had apparently written months before the murders. He'd written it to his cousin. In the letter, it made mention that he was scared of his dad, and the dad was coming into the room at night and molesting him. Now, the thing about the letter was that letter never surfaced ever during the criminal case, and in fact only surfaced, I think, in 2015. And so there's questions about that letter as well, as to whether or not that letter is truly a letter that was written 8 months before the murders, or was it written at some point long after the murders and used for this purpose. A lot of questions, a lot of unanswered questions.
The DA stressed the rehabilitation of the brothers, and that plays a huge role in deciding on resentencing.
It definitely does. And so the L.A. District Attorney's position on this is that two Menendez brothers have served close to 35 years in prison, that they apparently have been model citizens in prison. They've shown to some extent remorse. They've never gotten in any trouble in prison. And so his position is, hey, look, it's been 35 years. If they'd been sentenced to 50 years to life, they'd absolutely right now be eligible for parole because they were youthful offenders when it happened. California has a law that says if you're a youthful offender, you have a shot at parole after a certain number of years. And that's Gascon's whole platform. His whole platform is, we don't keep people in prison for no good reason if we think they've served a sufficient time and they've somehow been rehabilitated.
On that point, critics accuse Gascon of playing politics. He's facing a difficult re-election, trailing his opponent by double digits apparently. And he said that his office was inundated with calls after the Netflix series, so much so that they couldn't handle it. So is he playing politics?
Well, there's a big crowd out there that thinks he absolutely is playing politics, and their position is this, that George Gascon, came in to try to change things in Los Angeles 4 years ago, and at least a big part of the community here in Los Angeles thinks he failed miserably, that he's soft on crime, that his policies have made things worse here. And so he's up for re-election, and he's so far down in the polls that people think he really doesn't have a shot for winning. And so they think that what he did was he had a chance here to garner a whole lot of publicity with this Menendez decision. And this was a chance for him to be covered by, every major media outlet and maybe get some goodwill and maybe get some votes. That's the position of why it might be a political decision at this point.
The Menendez brothers still have a long way to go before they can be released from prison. A judge will have to agree with the DA's resentencing recommendation after a hearing. Then they'll have to face the parole board, and finally the governor can intervene. What do you think their prospects are for running the gauntlet, so to speak?
I think when you take everything into consideration, I think their prospects are pretty good because the district attorney, that office has backed the resentencing. I think when the judge handles this, I think they will be resentenced. And if they're resentenced, they basically eliminate the life without possibility of parole part of it. Well, then they're automatically, under the law, eligible for parole. So then it goes to the parole board, and they're going to look at all sorts of factors. And again, I think they have a pretty decent shot of having parole granted. Then the final step is the governor of California can veto that decision. And I've seen him do it recently on a big case where the parole board recommended parole for a convicted murderer, and despite public pressure, Governor Newsom went and vetoed that decision. So it's not a sure thing for the Menendez brothers that they're going to get out, but I think their prospects are looking pretty good. I think they have a strong chance that they'll run the gauntlet, and in a few months, maybe 3 to 6 months, maybe a little longer, but not a huge amount of time, they could be free men.
Thanks so much, Dave. That's L.A. trial attorney Dave Ring. The next step in the process is a hearing before an L.A. judge on the DA's resentencing recommendation. All arguments and evidence will be admitted at that time, and the judge will make a decision based on that. Coming up next on the Bloomberg Law Show, the trial of a Marine veteran accused in the chokehold death of a homeless man on a New York City subway car last year. I'm June Grasso, and you're listening to Bloomberg.
I was scared for myself, but I looked around. I saw women and children. He was yelling in their faces, saying these threats. I couldn't just sit still.
Jury selection began this week in the trial of Daniel Perry, the Marine Corps veteran charged with recklessly causing the death of a homeless man by putting him in a deadly chokehold on a New York City subway train last year. The death of Jordan Neely ignited a firestorm of protests, debate, and division across the city. Was Penny a good Samaritan or a vigilante? Penny says he was trying to protect himself and the other passengers because Neely was threatening them.
The three main threats that he repeated over and over was, I'm going to kill you, I'm prepared to go to jail for life, and I'm willing to die.
Joining me is criminal defense attorney Jeremy Saland, a former Manhattan prosecutor. How much of this debate about homelessness and mental illness and safety on the subway, how much will that bleed into the trial?
These are issues that hit home for many New Yorkers, but what happens outside the courtroom should remain outside the courtroom. What happens inside the courtroom should be regulated by the four corners of the law. I would not expect that any of it should come into the trial. The question is not what Jordan Neely did or didn't do days, weeks, months, and years before, criminal record, mental health illness, being homeless. In that moment in time, was Daniel Penny justified in taking action to subdue Jordan Neely and then ultimately cause his death, whether recklessly or negligently, as alleged by the prosecutors?
There's a 4-minute video of Penny pinning Neely to the ground and placing him in a chokehold while two other passengers help to restrain Neely. And both sides say they're going to use that. How will they use it differently?
Well, I think that the defense is going to try to show that what Penny did was very reasonable in that moment. And he's holding and pinning this individual to the ground. And, there's other people who are helping him do so because they're equally concerned about the volatility and the immediate and present danger, if not threat on lives of people on the subway. Whereas the prosecution is going to show a guy who was subdued and the hold around the neck and the chokehold, and probably concentrate more on that, which ultimately, if you believe their theory and they prove beyond a reasonable doubt, caused him to lose consciousness and ultimately pass, setting aside whether or not law enforcement did CPR and should have done CPR. So it's the same video, obviously, but one is going to try to demonstrate it was reasonable in the moment. The other one is going to try to demonstrate it was negligent or reckless and beyond the pale, if you will.
Neely reportedly had mental health and drug addiction issues. Will the defense be allowed to bring in his psychiatric history and the fact that synthetic cannabinoids known as K2 were found in his system?
First of all, Judge Wiley has been around the block in terms of the criminal law and criminal justice for years. He was actually my deputy chief when I was a prosecutor, and he's been on the bench a long time. I trust that he'll make the right call, and in this particular case, I think you have to set aside the noise. And again, not looking at his criminal history, not looking at his mental health issues. Was it relevant in that moment to the determination and the reasonable person analysis, if you will, of Daniel Penny when he observed this man throwing down his jacket, saying something along the lines of, I don't care if I go to jail, or whatever he might have said, and the reaction of people. So you have to limit it, because you can't twist the jury and provide evidence that is not relevant into the determination and decision making. Daniel Penny didn't know about the prior history. Daniel Penny didn't know about the mental illness. Did K2 cause Neely to act in a certain way? Maybe that could be relevant, but what did people see? What does the video show and demonstrate? And what happened in that moment is really important factor, not days, weeks, months before.
The medical examiner's office found that he died from compression to his neck as a result of the chokehold, and the manner was homicide. The defense said it's going to attack the ME's report and bring up potential other causes of Neely's death, including high levels of K2 in his bloodstream. That usually works in movies. Does it work in the courtroom?
It can work in the courtroom. I don't necessarily believe the K2 is relevant to the reaction and behavior of Daniel Penny, but it can absolutely be relevant to try to establish that the K2 may have been that proximate and actual cause of death to Jordan Neely. And I assume we'll have an expert to try to establish this. I believe that the big concern here is you have to make sure that you separate those jurors who have preconceived notion, whether it's race, whether it's politics, whether it's subway safety, take them out of the equation so that that jury objectively analyzes the evidence that's presented in that courtroom. So it does work. It absolutely can work. It's not an easy task or an easy lift, especially with such a charged case from the emotional perspective.
Both sides are going to call witnesses who were on the train, and it appears that their level of concern about Neely's behavior varied. Some said they were afraid. Others said, no, they see this all the time on the subway. How important are their accounts?
The words that they use are going to be critically important, because that video only shows a section in time. It doesn't show that imminent threat, because remember, by law, there needs to be that imminent threat of that serious physical injury or death even, to allow for the justification defense or self-defense, if you will, of yourself or other people. So beyond that video, how do these people perceive those moments? How do they react? And I'd be very concerned as Daniel Penny's counsel and Daniel Penny personally, if witnesses are going to come up and say, you know what, you see this all the time. You put your head down. I'm a New Yorker. I've been around the block. I've ridden these subways late at night. You just ignore that moment, and the threat, if you will, goes away. Because remember, too, it's not about just being scared or nervous or anxious. It's not a Kansas or Texan standard of riding a New York subway. It's arguably a reasonable New York standard, or just a reasonable standard of what was observed in the moment. So the words and the specificity of why and how they believe that they were physical or serious physical danger or imminent death, that's so important. So important. Not just that I'm scared.
What about the fact that he was a trained Marine? Does that come in?
It very well can come in if there is evidence that he knew and was aware of this type of chokehold and how to apply it and use it and the potential consequences of it. Because remember, it's not an intentional crime, but did he know of these risks to Jordan Neely, and did he just really ignore those risks? Was there a substantial likelihood or risk that his actions were going to cause another person's death and he ignored it? And if Daniel Penny was aware and knew and had that skill set, I believe that it should come in. It should be relevant.
What does the prosecution need to prove to get a manslaughter conviction?
When you're charged with manslaughter in the second degree, what the prosecution has to allege is that you recklessly caused the death to another person. Reckless is that standard. Whereas criminally negligent, and that's the lower felony, that's the Class E felony, that when you commit these acts, you fail to sort of perceive that there was this real substantial risk that your actions would cause that other person's death. So the recklessness is different, and it's more severe than the lesser, if you will, criminal negligence.
So the question looming over the trial, like every trial basically, is whether he's going to testify himself. And one of his lawyers said he'd be a great witness. We anticipate that he will, but that will depend on how the trial goes. Does he almost have to take the stand to explain his state of mind at the time?
Defense attorneys, such as myself, we don't always show our cards like the prosecution does at this point in the trial process. A lot of this hinges on that witness testimony. Yes, that video was important, but I think that video can work against Daniel Penny too, because, if someone is quote-unquote squirming, as was used in the terminology by Daniel Penny, that's not a favorable term. And for all those minutes to hold that person there, what are these witnesses going to say? Are they going to articulate how and why they were fearful for their life, for their physical safety? Because if they don't, then Daniel Penny has to testify. If they do, and it's clear of this imminent threat and danger, then maybe Daniel Penny doesn't. But I would expect him to. I would suspect he will testify because he probably will come across as a sympathetic person, not trying to intentionally hurt another man, but doing what he thought was the right thing in that moment. True or not, that's for the jury to decide, but I would expect that he would testify.
Police interviewed him on the day that Neely died, but then released him. That was criticized by some elected officials, and protesters demanded that Penny be arrested. Will that come in?
So issues of statements that are made, whether you're in custody and it's an interrogation as a matter of law, those issues have already been litigated. It could very well come in, and I would expect it to come in, that he was questioned and arrested only after the fact. Because the prosecution wants to tell a complete story. They don't want to seem like they're hiding the ball and misrepresenting. They want to explain why that occurred. Because if I'm the defense, I want to seize on that and say, you guys didn't arrest me initially. Look at, only because there's political pressure, only because of his outside voices and the issues of race and the issues of subway safety and politics did my client get arrested. And that's not just or justice. So I would expect it to come in with both sides trying to rationalize or reason why. And I will say that this is not incredibly atypical. Certainly most people are arrested in the moment, but there are times that not only does the NYPD not make an arrest initially, there are also times when prosecutors' offices do what's called a DP, or a decline to prosecute a case, even after the process has started, for further investigation, only to later make an arrest. So this is not necessarily typical, but it's not atypical either.
So what kind of juror are you looking for if you're the prosecutor, and what kind if you're the defense?
Starting with the prosecution, I'm looking for a real New Yorker, which is the opposite of what the defense is looking for. I don't want my Florida, Texas, California, Iowa transplant. I'm not looking for the guy or gal who's been around the block once because they had to walk to school or their new job and they're so excited to be in the big city, bright-eyed and excited. Or maybe mom and dad are paying the rent. That's the person that the defense wants, because the defense wants that overreacting individual who is not familiar with the subway life, who's not familiar with quote-unquote Gotham. Manhattanites are very, very different, who've ridden that subway, who've lived their lives. So that is the type of juror that we would expect the prosecution to want. Say, you know what, put your head down, walk away, this too shall pass.
Would you rather be the prosecutor here or the defense attorney?
If I had to take a side, which really sounds awkward saying that because this is such a tragic case no matter the result, yeah. But if I had to take a side from a legal perspective, I would want to take a side of the prosecution. I think this is an uphill climb from what I have seen. Granted, due process, 100% every single person, every single time. And the process has to run its course. We'll see the evidence. But that video is not some overwhelming piece of evidence that would say, oh my gosh, Daniel Penny, wasn't reckless or negligent. Remember, not intentional. And those witnesses on the subway, from what I have read, there's nothing so overwhelming. Oh my gosh, if you've ridden the subway in New York, this happened. This happened. It's terrible. It's sad in terms of people having episodes or manic episodes or misbehaving or even getting aggressive and violent. But that's something we see, and I would not want to be on the side of Daniel Penny, but let the jury decide that. Let's let due process run its course.
After 5 days of jury selection, not a single juror has been seated yet. And interestingly, the judge has decided that the jury will remain anonymous due to threats made to the prosecution and defense. The trial itself is expected to take 6 weeks. Thanks so much for joining us on the show, Jeremy. That's criminal defense attorney Jeremy Saland. Coming up next on the Bloomberg Law Show, the stars of the critically acclaimed Franco Zeffirelli movie, Romeo and Juliet, file lawsuits more than 50 years after the film's release over underage nude scenes. I'm June Grasso, and you're listening to Bloomberg.
The world's most enduring love story is the motion picture to be seen forever. Romeo and Juliet, starring Leonard Whiting and Olivia Hussey as the star-crossed lovers.
Oh, Romeo, Romeo. Wherefore art thou, Romeo?
It was the first time those famous lines were spoken on screen by a teenager around Juliet's age. Franco Zeffirelli's 1968 film is considered one of the best screen versions of Shakespeare's Romeo and Juliet. But a brief nude scene with Olivia Hussey and Leonard Whiting, the two real-life teens playing the star-crossed lovers, is still causing controversy today. Hussey and Whiting sued Paramount Pictures 54 years later, claiming the scene amounted to child pornography and alleging they were duped by Zeffirelli into appearing nude. Judges have dismissed two versions of their lawsuit, and they say they're going to appeal. Joining me is intellectual property litigator Terence Ross, a partner at Katten Muchin Rosenman. Terry, tell us about the background of this lawsuit.
This is all rising out of a movie version of Romeo and Juliet that Franco Zeffirelli, one of the great film directors of all time, wrote and directed. It was filmed in 1967, released in 1968, so it's quite old. It was a critical hit, received 4 Oscar nominations. It was a financial hit against a budget of about $850,000. In North America alone, they made $14.5 million, made quite a bit in the UK and Europe as well. And so by all measures, it was a hit. And what really attracted people to it was the very first film or stage version that had actually used teens as Romeo and Juliet as William Shakespeare intended to be used. If you remember the play, Romeo and Juliet are like 15 and 16. So Zeffirelli cast Olivia Hussey, who was 16 at the time of filming, as Juliet, and Leonard Whiting as Romeo, who was 17 at the time of filming. And obviously both of them were underage, minors. And in a scene in Act 3 that takes place in Juliet's bedroom, we see Olivia Hussey's bare breasts and Leonard Whiting's bare buttocks. Neither of them are particularly long camera shots, but they are there. The actors were paid about $2,200 in 1967 money for the entire film. Olivia Hussey went on to have, a solid career, not top tier, and in later years did a lot of voiceover work. And Leonard Whiting had not much of a career thereafter, had a few parts, but sort of drifted off into obscurity. And indeed, on multiple occasions, wrote to the studio saying he really should be paid more money for his work on Romeo and Juliet, which he was not. And so that's the background to where we are.
What were the grounds of their first suit against Paramount more than a half century after the film came out?
So the gravamen of the suit was that this nude scene amounted to sexual abuse. The actual lawsuit filed in late 2022 in Santa Monica Superior Court. So keep in mind, this is a California state court. It had 7 causes of action. And listeners unfamiliar with California litigation may go, what the heck? But this is the way litigation works in California. You toss in, all these, what I call make-weight causes of action on top of what really matters. So the first count was for sexual harassment. Then they had a claim for fraud, a claim for childhood sexual abuse, a claim for appropriation of likeness, which is a very trendy cause of action these days, cause of action for intentional infliction of emotional harm, cause of action for negligence, and bizarrely a claim for unfair business practices. And the lawsuit sought $100 million plus punitive damages. But the gravamen of the complaint, as you say, was really these nude scenes, and when using minors in such nude scenes, what does that amount to at law? And so set aside the causes of action. That's what this lawsuit was about.
And they claim that they were sort of forced into doing the scene.
Yeah, exactly. June, they claimed they were told by Zeffirelli at the outset of the film that there would be no nudity. The actual scene involving the nudity was filmed secretly. The parents of the 2 minors did not know about it, did not know it had happened until after it was filmed. These things raise some suspicions in your mind, and apparently Zeffirelli was in sort of a creepy way hanging about Olivia Hussey, making comments about her breasts. It was very sort of creepy behavior on set during the scene, although I hasten to also say that neither actor has ever criticized Franco Zeffirelli since then over this. And he was not a defendant in the lawsuit. He passed away in 2019 anyway. But even in the press relations surrounding the lawsuit, they were not critical of him in any way, which is also sort of odd.
Did this 54-year gap play a part in the dismissal of the first lawsuit?
So California, in the last few years, passed a special law that temporarily suspended the statute of limitations in child sex abuse cases. Statute of limitations is sort of a deadline by which you file your lawsuit. The public policy reason behind it is that memories fade, evidence gets lost. It's really unfair to inflict upon a defendant a lawsuit for something that happened more than a certain number of years ago. Given all that has happened in the last few years with the Me Too movement, California passed this law that for a short period of time allowed victims of child sexual abuse to file again, so suspended the statute of limitations. So what happened here then was they saw this opportunity, and together, Olivia Hussey and Leonard Whiting, although it appears that Whiting was the prime mover in this lawsuit, found a lawyer and filed this lawsuit.
And why did a judge dismiss the lawsuit in May of 2023?
So Paramount Pictures filed what is called an anti-slap motion. It is essentially a law that was put in place by California and has been adopted by a lot of other states since then that protects creators and also citizens against having their First Amendment rights chilled through litigation. So citizen starts complaining about a developer and what they're doing, poisoning the environment perhaps. The developer brings a lawsuit against that citizen, and that coerces them into shutting up. Well, this was a mechanism for getting rid of such lawsuits so as to protect First Amendment free speech. And so Paramount filed that motion. And May 23rd, 2023, the judge in Santa Monica granted that motion and dismissed the lawsuit in its entirety. She made a number of important factual findings to get there. Probably the most important, and I'll try to quote exactly from the decision here, she found that this bedroom scene in Act 3 was, quote, not sufficiently sexually suggestive, close quote, to be able to invoke the temporary suspension of the statute of limitations. In essence, she's saying this wasn't sexual abuse or sexual harassment or taking advantage of a minor, given what was actually on the film. And therefore, she said the statute of limitations applied, and she tossed out the lawsuit. Now, there was a whole second layer to this, which is the actors had signed consent contracts at the time. Their parents had signed along with them, because as a minor, you're technically not held to any contract you sign. And the judge went on to find that even if you tossed out those consents from back in 1967, the behavior of the two actors subsequently, once they became adults at age 18, constituted ratification of contracts. And she pointed out to numerous instances in which critics had attacked over time this particular scene with the nudity, and both Olivia Hussey and Leonard Whiting had defended the scene and said it was perfectly appropriate, and had defended Zeffirelli for including it in the movie. And that the judge found to be very curious behavior and said that as a legal matter constituted ratification of the consent contracts, even if they had been minors at the time.
But they filed a new lawsuit in February of this year because there had been a re-release of the film.
In 2023, like all the movies nowadays, movies that are worth anything, a company called Criterion Collection brought out a digitally enhanced DVD that restored the film, air quotes around restored, and released that. And so a smart lawyer said, well, this restarts the statute of limitations. In February 2023, refiled the lawsuit, same causes of action mostly. And again, Paramount Pictures filed a motion to dismiss. And again, the judge said, no, this re-release may be digitally restored, but it's not in any significant way different, particularly with respect to the bedroom scene. And therefore, you're stuck with the statute of limitations date from back in 1967. And I'm going to dismiss this lawsuit again on the same grounds as before. And apparently the plaintiffs are going to take an appeal of this, and there's lots to take an appeal with. But I think that is going to be the most interesting part of the appeal, whether or not a digital re-release constitutes a restart of the statute of limitations.
What are some of the other appellate issues they might raise?
So they're going to argue that the nude bedroom scene actually does constitute child abuse, verging on child pornography. That's going to be challenging because the judge here made a fact finding that it was not sexually suggestive in sufficient manner to violate the law. Trial court judges' fact findings are granted great deference on appeal. And in order for the appellate court to get around that, they would have to say the fact finding was out of the realm of reasonable possibility. And that almost never happens. And when it does, it usually means that the judge has made a grievous mistake, usually a mistake that just didn't understand the record. That's not the mistake being alleged here. On appeal, the plaintiffs will say that she just got it wrong, subjectively got it wrong, and that is going to be a hard argument to make to the appellate court.
I understand legally why the suits were dismissed, but something does seem wrong here. I mean, they were minors doing a nude scene that they didn't know about before and their parents didn't know about before. And what's pornographic? Shouldn't that be something decided by a jury rather than one judge?
I think it's a very hard thing to decide. I think what is even harder is to put yourself back in time to 1967 and try to understand what would constitute child abuse under the statute. There's the famous comment from, I think, Justice White. How do you decide if it's pornography? He said, I know it when I see it, which is not much of a standard. This is not, strictly speaking, a case of pornography. It's just whether or not this was sexual abuse sufficient to suspend the statute of limitations. Now, one of the facts that came out that I still am sort of shocked by is the Motion Picture Association of America apparently gave this a PG rating when it first came out. I don't know what the rating is now on the re-release, or even if they rate re-releases. But that sort of argues at the time people didn't think much of this scene. And as I said at the beginning, these were sort of fleeting glimpses. That would seem to strike me as a pretty strong factual indication of what people thought back in 1967 and 1968 about the scene. The critics really focused on the fact that this was the first time ever in a film or stage version outside of high school, but a major production of Romeo and Juliet where they had used teens. And they just didn't then make the jump to, but you had naked teens. They were, this is brilliant. It's Franco Zeffirelli. I will say this, June, your instinct is spot on about our contemporary reaction to this. If something doesn't feel right at your gut level about him doing this, he's dead, he can't rebut this, but telling them that there wasn't going to be any nudity, then doing it a separate scene all by itself without the parents on set, not ever having told them, sort of secretly filming it. Now, the rebuttal argument could be, well, you wanted to take into account sensitivity of the actors, as they do nowadays, and you empty out the set for the most part, and that may have been it. But, nowadays we have intimacy coordinators for any scenes that involve the smallest amount of nudity. None of that was present back then. And these were teenagers, and they talked about the problems they had mentally coping with this as teens, having people watch them in this way. And so that's why, I think your gut instinct is exactly right. It just doesn't sound right. Whether or not that's a lawsuit, I don't know.
I guess we'll see what the appellate court thinks about it. Thanks so much, Terry. That's Terence Ross of Katten Muchin Rosenman. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.